This is when I'll enter the fray in terms of any questions you guys have with regards to what I'm observing inside court. And then some Q&A with the audience. I'm hoping the online team will also be able to field questions to me that we can pose to our panel of experts. And then we'll have closing remarks and my favorite part, refreshments. So let's then get straight into it with our opening remarks and welcomed by the Executive Dean of the Law Faculty, that is Professor Wissal Domingo.
Thank you so much, Slendelo. And I think this is the first time, it's a first for me to be introduced by a news anchor from ENCA. So thank you for that. And I do want to say thank you to you for joining us tonight. I know you've been part of it, and I know that everyone should know our colleague, Mr. Alton Hart, because he's often on ENCA as well. But many thanks for taking time, and I know you have a very busy schedule, and it's much appreciated by the faculty. So colleagues, Sanibonani, Dumelang, Goeienaand, and good evening. This case, as the titles of this public lecture says, continues to grip the country and the legal fraternity. And so I want to extend a warm welcome to those that are joining us in person, and also to our colleagues and friends who are joining us online. I am looking forward to the engagements tonight, whether they are law or otherwise. We are open to all those discussions. And Slendela, I want to say by the end of this, we may honor and award you an honorary LLB degree. So I'm not going to speak much about the case because that's not my job tonight. We have, and I want to just mention Mr. Louis Kuhn, who is an assistant lecturer in the Department of Public Law, and then Mr. Alton Hart from our law clinic. And so I'm going to say, without further ado, I am now going to hand back over to my colleagues. Thank you, and please, we look forward to a robust engagement tonight. Thank you.
Thank you so much, Prof. Definitely, I'm very excited to be here because I was telling Mr. Hart that, it's always great to actually just understand what you're observing and to be able to speak on what you're seeing unfolding with some kind of authority, and also to just clarify a lot of the nitty-gritties of the law, the kind of arguments that you're hearing in court, the objections and so forth. I think it's going to be very interesting for you guys. This is a great time for you guys to be actually studying law in particular, because there's a lot of cases, I think, in the public eye, apart from this one, that are unfolding within the public space, which, of course, can facilitate some debate. But, of course, next on the program, I'm going to now hand over to Mr. Louis Kuhn, who's going to discuss the developments in the broadcasting of the court proceedings. Over to you.
Good evening, everyone. I'll try to be very disciplined with time, and as my students who are here know, that's not always my strength, but I'll try to be quite disciplined. And I have the privilege of giving you essentially a brief introduction of how the law actually developed to allow you to be able to watch trials on television in the first place. Because if we think back to 2007, in a obiter remark by the Constitutional Court in the case of South African Broadcasting Corporation versus the National Director of Public Prosecutions, the court there made a remark where they said, ordinarily, it will not be in the interest of justice for trial proceedings to be broadcasted. And here we are years later, and it's become quite common for us to see court proceedings being broadcasted on television. And we deal with these issues of balance, the privacy of the accused. I mean, after all, the accused is presumed to be innocent. We're dealing with witnesses. We're dealing with concerns over what people call the "you are on camera" syndrome. Are we going to see the witnesses play it up for the cameras? And I mean, these concerns were all considered by the courts, and that probably influenced the remarks by the Constitutional Court so many years ago when it said that ordinarily it will not be in the interest of justice for court proceedings to be broadcasted. But then, of course, we all know that the Oscar Pistorius trial, and that is, of course, the multi-choice judgment, which deals specifically with the broadcasting of court proceedings. And Judge President Mlambo was actually criticized by some academics for that judgment. The view was that he had ignored the previous remarks made by the Constitutional Court, where it was said that ordinarily it would not be in the interest of justice for court proceedings to be broadcasted. But he goes to the principle of open justice, and he says that in this day and age, I cannot countenance a stance where the doors of justice are shut to the majority. One can not only have those who can actually afford to go to the courtroom physically have this access to justice. And the media plays an important role into bringing these court proceedings right into people's living rooms. It should be open. And when we think about these privacy considerations, I think what we need to remember is that court proceedings are open in either event. Anybody can walk into the courtroom and watch the court proceedings. Of course, not every aspect of the proceedings, but for the most part, individuals can walk into the courtroom. And this was reflected on by the Constitutional Court in S versus Mamabolo in 2001 already, where the court noted that since time immemorial, it is recognized that the business of adjudication concerns not only the immediate litigants, but for its credibility is done in the open, where all can see. And we developed this principle of open justice under Section 34, which is your right of access to courts. And of course, in later on judgments where the court speaks about children as well, they also talk about how it relates to freedom of expression and access to information, because it is the reality of our country that most people will not be able to go into a courtroom to watch these court proceedings. It is a luxury that is not available to everybody. And this issue was really finally settled in the case of Van Breda versus Media 24, where again the old objections were raised that criminal trial proceedings should not be broadcasted. And there the court effectively set out the position that governs our law in respect of media access to the courtrooms today. And I believe it was late last year that we got the updated guidelines from the South African National Editors Forum, which is meant to guide journalists in also understanding what we can effectively call the new normal. So we've moved away from this instance where the broadcasting of court proceedings are rather rare to a default position of openness. Now, naturally, the court can, of course, regulate these proceedings, and nobody can just walk in and broadcast court proceedings at will. There are, of course, safeguards, but that arises from the court's inherent jurisdiction to regulate its own proceedings. So the idea being that generally, you need to give effect to the principle of open justice, which includes allowing the broadcasting of court proceedings, but the court can implement safeguards to protect these competing interests. As we said, we have the issues of privacy, of the accused, of witnesses. And earlier this year, we saw a judgment in Rode versus S, where the victim's daughter, so it was a domestic violence dispute, the mother of the witness had unfortunately been murdered by her father, and she was to give testimony. And one of the things the court said there is that one cannot shut out the media completely. So what you can do to implement safeguards is, for example, allow the broadcasting of her voice but not her face, while the rest of the court proceedings can be broadcasted. You need to implement safeguards to protect the victims, but the default position is openness. The doors of justice must be open for all to see, and that serves a very important public function. It allows the public to be aware of the happenings in our courtrooms so that you may criticize the court, so that you may be aware of what is happening. And Justice Mlambo also made quite a controversial statement in his multi-choice judgment when he said that part of the reason to open the courts is to address a perception that the rich and famous are being treated with kid gloves. And that statement led to quite some controversy because some academics criticized Mlambo, saying that, well, there was absolutely no evidence to suggest that. But with my students, I like to do a quick survey. I say, how many of you think that the rich and famous are being treated with kid gloves? And often the overwhelming majority say that is the perception. So whether Mlambo was empirically correct or not, it is a perception that needs to be addressed. And opening the courtrooms to broadcasting is one of the ways in which we can do that. So effectively, this is how our law has been developing continuously, to open up the courtrooms to media, from a position where it was rarely broadcasted to a position where the default position is effectively openness. And only after that do we consider the balancing that's needed to protect these competing interests. I'll end there. Thank you. Oh, no. May I continue? So, of course, the guidelines by the South African National Editors Forum is very important because, as we can imagine, and we saw this in the Senzo Meyiwa trial, and unfortunately, broadcasting in the trial was temporarily halted over some concerns over journalists running after a witness, not mentioning any names, and it comes back to, yes, we need to open the courtroom to the media, but we also need to be sensitive that we're dealing with people, we're dealing with sensitive matters, we are dealing with a tense environment, and the dignity of everybody needs to be respected. At the end of the day, the witnesses didn't do anything wrong, for the most part, to end up in the witness stand, and they mustn't feel that it is becoming a particularly hostile environment. So the court needs to balance all of these interests and protect the witnesses, as they did in the Roda case earlier this year. So yes, let's open up the courtrooms, but also it's important to have these guidelines in place, and the courts will naturally continue to develop more safeguards as they go ahead. One of the remarks in the Van Breda case was that generally, you should be permitted to broadcast the testimony of expert witnesses. But sometimes if it's a lay witness, additional safeguards may be needed. Naturally, if it's children, you cannot broadcast the faces of children, nor are you allowed to reveal the names of children. And that, of course, was considered by the Constitutional Court in the Centre for Child Law case in 2019, where they said, yes, we need to protect open justice, but if we look at children, we give heightened protection to the interest of children, and then we need to distinguish between what's in the public interest and what's interesting to the public. I'll end there. Thank you.
Absolutely fascinating. I think, of course, we're going to have more questions and comments from the floor, online. I know I do have a few, and I know some of you guys may have some questions for me, in particular with reference to some of the media behavior frenzy in courts, and that's why I'm here. I think for a lot of people, what they don't understand is, especially for those who are watching it, the kind of pressure maybe broadcasters themselves have in terms of getting things first, getting the information, as quickly out there as possible, getting those visuals live. So those are things maybe that I can break down for you. But just to give you guys more background, in terms of the case itself, the Senzo Meyiwa trial, mind you, is 8 years or so in the making. This murder happened on the 26th of October 2014. In Vosloorus, at least 7 occupants in the house, but of course these are all details that I'm sure Mr. Alton Hart will be getting into. But I think maybe those are just some of the key issues that you should keep in mind when we start to unpack how this trial is unfolding, how slow it's been, just how long it's taken us to get here and why there's public interest. Mr. Alton Hart, just to give you some background on the Senzo Meyiwa case.
That was my intro. You can see there was a couple of shorties here. So I'll just help myself to bring the mic to where I am. Guys, obviously, this is an interesting thing, and I think now 8 years in the making. When is it? In the next 2 weeks, it will be exactly 8 years since the former captain was fatefully wounded and actually then died of his wounds. And obviously, then things happened. It was for a long time, things went quiet. And we thought, nothing is happening. Oh, and then the old saying comes up, the wheels of justice is turning slow. I don't trust the police. I don't trust the judiciary. And then it's like a whole lot of trust issues amongst people that aspire to study law and actually the lawyers. Because we said, they're going to do as they usually do, swipe it under the carpet. But eventually people were charged in 2020. And I will make a bold stance and say the people that was charged in 2020, I don't believe it's the right guys. I'll make the bold statement. And you guys can ask me why I say so. I'll make that bold statement. You put your money where your mouth is. And we'll unpack it. And that was the first time that we actually saw the people that was alleged to have killed Senzo Meyiwa. And I say, and I want to put an emphasis, alleged. Until the court finds them guilty and they don't appeal, it will be alleged. So don't think, okay, they've got the right guys. Because why I'm saying this is that why is there 2 dockets? That's also one of the interesting things. For me as a lawyer, it's red flags all over the place. You cannot have 2 dockets for the same cause of action. You guys have studied law or you are busy studying law. You know now what is the cause of action. 1 cause of action, 2 dockets. Why? For me, it was, first, if you have first set of suspects and you attain more, then we say 5 plus 7, we get to 12 suspects. And they will eliminate them as the trial proceeds or unfolds. And that is one of the major talking points that I think we should engage, and you guys can ask me about it. And then obviously, as lawyers, I always speak to my students, and you guys can see, I don't look that old, but Mr. Louis Kuhn, back then, he was one of my students. I just don't look that old, eh? And you can see, now I can brag and say, that's my student. Did you hear the interesting things he was talking about? And that was a big thing. And I know for some people it's like COVID came. And if COVID didn't came, we wouldn't have actually realized how important the media is actually playing in court proceedings for us sitting at home. Because we could sit in the comfort of our houses and actually follow proceedings that we are interested in. And that is also one of the big talking points. But for lawyers, my starting point is always behavior and behavior in court. Yes, you can disagree with a judge. You can disagree with your opponents. But what we saw, my former colleague, because he's now disbarred, Advocate Tefu, did. It's unacceptable. Yes, if you disagree with court, you make it nice English. There's a lot of English. Oxford, you don't need to use the brace terms that he was using. But I mean, that behavior of him, it's one of the talking points. And I mean, the legal fraternity was up in arms all about it. And that was the first application that I saw a guy got so quickly disbarred. It was like 3 months and he was disbarred. Some, they would go through disciplinary, appeal, and a whole host of, and maybe a year later you get disbarred. This one, they were onto it like a flash. So that was also one of the big talking points, and I think big things. And obviously the accused then decided to abandon their bail. Why did they decide to abandon their bail? And now suddenly you see accused number 2, and this morning he was back in court, actually now saying he wants to ask for bail. And this is now on the backdrop that he was the only one that was already identified as one of the possible perpetrators. Okay? But I still stick to my story. I say, I don't think the first 5 is the right ones. I still stick to my story. So you can say, but witness pointed him out. Then I say, go read your criminal procedure, doc identification. Nah. You guys now know about doc identification. If you don't know, the prof is here. She can see you don't know your work, so you better go learn. So that was some of the interesting things. And I mean, there were so many things and over the years, and also the delays. And I know Lindelo has unpacked some of them. There was also delays. And specifically, one of the topics is like, why does it take so long? And we had to unpack as to what actually made the trial to take, because obviously one needs to understand, when an investigating officer, and this is normally where it starts, a complaint is lodged, obviously the state becomes then dominus litis. The state becomes the complainant, especially in this one where there was a fatal injury. The state becomes the complainant, and then obviously you have your witnesses. Now the docket is registered at a police station. Then the investigation work starts. I'm not saying the investigation is good or bad. It starts. Then once the investigation is finalized, that docket is then sent to normally a control prosecutor or a senior prosecutor, or it can be the NDPP. In this case, you see there was 2 NDPPs, or not NDPPs, it's like DDPs, Deputy Directors of Public Prosecutions. That actually the one from South Gauteng and the one from North Gauteng, 2 different dockets, now the 2 different dockets. And they had to make a decision, do we have enough evidence to prosecute? So that's where you are. You check, do I have case against the accused? If not, I make entries, what they call Part C, the investigation diary. They make certain entries in there. Say, investigator, I want you to go and get this from maybe Mbusam Tiani, or this from Kutso, whoever the witnesses is. You need to follow up until they find, okay, now we are ready to proceed. Then they will charge the people, and once you are being charged, you then have a right for bail. Section 60 now kicks in, read with Section 50, subsection 6 of the Criminal Procedure Act. But you guys must never forget, depending on what court you operate in, that the rules of the court is also applicable. So if it's in a magistrate's court, then you have the magistrate's court rules. If it's in a high court, you've got the uniform rules of court, and you need to play by those rules. Although the CPA is governing the process, these rules is also there. And what magistrates and judges will kill you for is practice directives. If you don't follow practice directives, you're dead in the water. You better know that. And that also played down. And this is the things that the reporters normally see happening behind the scenes. We just see the nice part on the TV, what's happening. You don't see the inner workings behind the court doors, behind the chamber doors. You don't see those things. And that is most probably also things that we need to touch on and unpack. Okay, so if you have questions pertaining to that, we can venture into them and say what happens and what you've picked up. And that was like some of the things that can also delay. You bring in an application for whatever reason, and I saw Advocate Tefu brought a couple of applications, and the worst thing of that defense team is that they were not working in tandem. The one was pulling this way and the other one was pulling that way. Now, as a criminal defense attorney, when you work with other attorneys on the panel as defense attorneys, you guys need to poke holes in the state's case. That's what your job is, to show that the witness is not credible and the state's evidence cannot be trusted. Then your job is done. You don't need to prove that you are innocent. You just need to say, witness is not. The state must prove beyond reasonable doubt that your client has committed the offense. Once they go and that there's a prima facie case to answer to, that's when that sort of a slight onus moves to you as the accused person to do certain things. But that was all that you found in the trial that actually delayed it. And there's some other things that you guys might recall, but that is some of the things that we can talk about and you guys can ask. And I feel like always not to stay in here so that you hear my voice, because I don't like hearing my own voice, but I like to engage people so that we can actually unpack and actually make it sound like it's a conversation and we can actually clear up the air, and for you guys, aspiring lawyers, so that you can also know how this process is unfold. Because what you see is 20% of what really happens in a criminal or any trial. You just see 20% that part on the TV. But the pre-trial preparations, what goes in before that, that becomes then a critical thing on how you prepare for your trial. And sometimes people think, yeah, I'm going to cross-examine that witness. But sometimes you don't need to cross-examine a witness because the witness did not give damning evidence against your client. And I can make one example. I had a client once where they said, did you speak to your father? And it was a minor child. They asked the child, did you speak to your father? And the child said, before she has to testify, yes, I spoke to my father about the case. And that already red lines, where you say, you can't, as a witness, you should not be speaking to somebody else. But then the next question is, what did you speak to your father about? And the answer was, I spoke to my father. My father said, I must just tell the truth and nothing but the truth. So you need to know where you stop with your cross-examination. And that was 1 to 5. And we lost the case because the child said the truth, and then she was found to be a credible witness. So you need to also gauge those things and how the inner workings of your law of evidence now comes into these trials. But that's in a nutshell. I didn't cover everything, but if there's questions, keep them coming, and we'll tend to them. Thank you.
Thank you. That is Mr. Alton Hart, of course, from the UJ Law Clinic, giving you a bit of background in terms of where we are with this case. And like he said, we're dealing with a matter that has 2 dockets, from what I understand, unprecedented, not normal within the law, prescripts of the law, and of course, causing a lot of interesting developments within this trial, because we've got what, to quote Advocate Mshololo, that's the lawyer for accused 5, she said, we don't know if those who were in the house are witness suspects or suspect victims. Quite an interesting term that she used there. So right now, we're going to then, of course, get into a panel discussion. And I was hoping to remain over here because it just makes it easier to be able to field questions, write down. I was hoping to invite the Prof. I don't know if she's willing to maybe participate with us. The more the merrier. Okay, the Prof wants to engage with the audience as well, so that's not a problem. Just to remind the team as well, if there are any questions online, I don't know if there's a platform for them to be able to engage, just write them down for me so I can read them out for the panel. And of course, I have no problem answering questions from here as well, unless you guys really need me on that chair, but I mean, okay, they really need me on this chair. Okay, cool. So maybe for the first part, let me just field some questions from here. The audience, the floor is yours. Anything that's come out so far, I'm noting 1, 2, 3, 4, 5. Okay, let's start with 5. Let's start with 5. 1, so 1, 2. The gentleman behind you, ma'am, 3. And then 4. Someone will say 5. No? Okay, cool. So just introduce yourself, what year you're in or what you do, and then your question, of course, to whoever you deem it fit on the panel.
Good day. My name is Monique. I study LLB degree. I'm in my 3rd year. So my question to Mr. Kun, just with regards to the safeguards that you mentioned. So in terms of witnesses being compellable under Section 196, so they are competent and compellable. But now, let's just say in terms of the safeguards, if they're not aware that there are safeguards implemented, but they think that they are forced to actually attend a trial, how do we make that more aware to people that there are safeguards in place, as opposed to just you're forced to attend a trial as you're a competent witness? And then also just in terms of Mr. Hart, just with respect to children, I heard that you mentioned that as being a competent witness. So in terms of being a competent witness, it's the court's discretion, correct? In terms of they do a test to see whether they are competent, and that they can testify under Section 164, I mean. But now, in terms of this, how do we actually go about or go around that? Because I know that they have intermediaries or they have people to assist the children in understanding what's going on. But how do we distinguish that they are a competent witness to testify in a case? Is there specific remedies or specific criteria to say that they are capable of actually testifying? That's just my questions for now.
All right. do we take all the questions? Yeah.
Take those 5, and then we'll answer the first 5, and then...
I'm going to stand up if you don't mind, Program Director. I'm energized, legally energized. So, Slindela, thank you so much to be in your presence. I was one of the frantic critics with that incident of the chasing the witness. My name is Rudy Peterson, and I'm the stakeholder and government and stakeholder relations contact here at UJ. So I'm going to start with the media. So unfortunately for me, I think sensitive cases, journalists chasing after witnesses is a total no-go for me. And I tell you why. It's very delicate, it's sensitive. Expert witnesses may be a different kettle of fish. They can be questioned by journalists, but ordinary witnesses, it's a problem. And I think in that instance with that witness, I think the witness was intimate, not sure what to do. So we learned as a public to say journalists questioning witness in sensitive cases is perhaps a no-go. So that's just, and I'll take the remarks from the colleagues. I have a comment. I see we've got Kun there, and I wonder, is there a relationship to the Supreme Court candidate? By the way, I must say I like his style. I think as a Supreme Court judge, I think, I'm not sure, I just follow the interview in between, but I think for a Supreme Court judge, he's got real tenacity. So I think the two comments and then a question very quickly to give others a chance. In the public interest and in the interest of justice. You know, it's a delicate, it's a very, that's what's supposed to happen. But this trial, this Senzo Meyiwa trial is not it's a travesty of justice. It's a soap opera. And I want the colleagues to comment. It's, for me, not a trial. You would see that where Tefo, Judge Maumela, challenged Tefo and said, hey, that comment you made, I don't know whether you went to night school law or you went to day school. I'm sure you guys know that. So whenever you watch the trial, it's like you're watching a soap opera. You look at that one, I don't know which witness is it questioning one of the witnesses, and he's on the witness case, and there was the issue of interpretation, and that just, it's a fracas. So for me, sadly, so I want your comment. It is supposed to be a trial on the executive dean. We're supposed to learn from it. Our students are supposed to learn. I see the justice, but I see a soap opera, and I want them to comment. 8 years in the making. It is a travesty of justice. Justice delayed is justice denied. It's far too long. My comment and question is, how can our court system be improved? I mean, we've asked that question in the public, Mr. Hart, many times, you've heard it. You go to any platform, how could we speed up processes? 8 years of trial, it cannot be. I'm not sure, obviously there's court proceedings and so on, but certain trials, certain cases needs to be, sped up. So where we are 8 years down the line, there is so much tenacity, innuendos, and you name it, so it becomes a convoluted thing. I'm interested to see what will happen, but for me it's a travesty of justice. It's more, this Senzo Meyiwa trial is a soap opera. Sadly so, I'm a Bagania fan myself. And being a Pirate supporter, I'm sad that this has taken so long. By the way, I knew him personally. He was a young man. He came to my house even. And it's very, very sad that it has taken, it's 8 years now, and it can take even much longer, as you have rightfully said. Therefore, I don't think I've got soap opera. My notes is covered. Thank you, Madam Speaker.
No, we're now at 3, ma'am, but maybe you first want to go now.
Yeah, so I think 5, who are the 5? I think you are 4, ne? You're
3.
4. 3. You're 4, she's 5. Next round.
Okay, perfect. So my name is Samantha Smith. I'm a final year BCom law student. So I have a question for each of the panelists. Firstly, ma'am, for you, the media. So Mr. Kun spoke about basically playing it up in front of the cameras. Do you feel that the media also does that in a certain way because they want to gather press for their specific news sites, and that's why we had the debacle in the actual court? So that was my question for you. Then, Mr. Hart, for you, you said that obviously, and we studied this, that you do not have to prove that you're innocent because you just have to poke holes basically in the state's case. But do you feel the fact that it's streamed puts that thing on the accused to show that they are innocent because they are now in the public's eye? And even if you only prove that, or it's not your job to prove that you're innocent, people will think poorly of you because it's streamed for all to see. Then finally, Mr. Kuhn, for you, you said that we must use these court processes to create awareness. But what about when these people are not found guilty and it now affects their human dignity? Because in the public eye, everyone's watching these trials, and now when these... Okay, but yes, that's basically my question. I think you got the gist of it.
Hello, my name is Bradley. I'm a first-year student at the University of Johannesburg. I have two questions. The first one is to Mr. Kuhn. You said that lay witnesses are usually protected by safeguards in which usually the face is not allowed to be broadcasted. But what happens when a lay witness, that is, decides to sit for an interview with the news and gives details of the case, and how would the court work around that? Do they still provide the safeguards, or because the person has already been publicized by the interview they would have had with the media, and how does that affect the case as a whole? And my second question is to Mr. Hart. This is not actually a legal question, I would say. You said something about the quick disbarring of Advocate Defo. There are theories that this was actually not a robbery, but it was a directed hit because they did not take things that were valuable in the house, and it looked like they were just trying to show that it was just a robbery where it was probably not. So do you think it would be possible that the people that are pulling the strings, that may be behind the allegation of this being a hit and not a robbery gone wrong, could they be pulling the strings in terms of speeding up the disbarring of Advocate Defo because he was maybe becoming a problem in the work that he was doing for the accused? Thank you.
Hi, my name is Inocentia Muloi, first year student, LLB. My question is directed to Mr. Hart. You spoke about 2 dockets. So is it like advantageous to the public to have a case where we have 2 dockets? Is it possible for the case to be solved and the justice to be solved when we have 2 dockets in the case? Thank you.
Fantastic. I'm now going to hand over to our esteemed panel, and then I will answer my question last. Mr. Kuhn.
Okay, so I'll start. So Monique asked about the safeguards, and I mean the witnesses, are they aware of the safeguards? So generally, the safeguards are implemented by the court. I mean, of course they can vary them, but often it's implemented when the media asks for permission to broadcast initially. That is when the court directs the conditions of how the broadcasting would be done and things like that. So it's not there to protect an individual witness. I mean, yes, it's of course the court considers the balancing of interest, and as we saw in the Roeder case, there was a specific witness who wanted specific parts excluded, but it's not generally a safeguard that's implemented for every individual witness. So it doesn't change anything in relation to whether they are a competent or compellable witness. The witness doesn't necessarily have a right to say that part of the court proceedings mustn't be broadcasted. Of course, they can raise objections beforehand, and in some instances the court will allow that. One of the arguments in the Roode case was Mr. Roode asked for the judge to be recused because he said that the judge was functus officio after he gave the initial order setting out the terms of the broadcasting. And the court said, well, that's absolutely not the case because it arises from the court's inherent power to regulate its own proceedings, which if it's your inherent power to regulate your own proceedings, you can change your orders. So it's not a right belonging to individual witnesses. That is, I think, important to know. Then in terms of the soap opera comment, I think that goes back to some of the concerns I also mentioned when initially we started talking about broadcasting, specifically this you are on camera syndrome. I'll let Mr. Hart speak more about that. Then the third question was in relation to everybody effectively now being aware of this person who was accused. And I think we also need to be honest. Whether those proceedings were broadcasted or not, everybody was going to be aware of this case. I mean, if we think back to the Inga Lotz case as an example, those proceedings weren't broadcasted, and everybody knew who Fred van der Vyver was. It was not broadcasting that essentially put it into the public spotlight. Yes, of course, television has a much bigger reach, but the reality is that most people would have been aware of these proceedings anyway, whether they read about it only in the print media or if they see it broadcasted. So unfortunately, that is the reality. One might actually argue that it being broadcasted shows the defense case more than when everybody just gets secondary information from it being just reported. So I think, again, it goes to this balance, but the reality is that most people would have been aware either way. If it's a controversial case like this, the media were going to report on it, whether it's broadcasted or not. Then the fourth question directed to me was specifically on lay witnesses. And again, if a lay witness decides to go and give an interview, the reason why the court in Van Breda mentioned that we might have to treat lay witnesses differently is because of these privacy concerns. But if you go out and publish your affairs on television, you've effectively waived your privacy. So that is not for the court to now try to protect you from yourself. Okay. Mr. Hart?
Thanks, Mr. Koen. I think Mr. Koen touched on most of the things, but also like when I go to competent witnesses or competent witnesses, obviously in the Criminal Procedure Act, one needs to check there is certain age limits where they say a person has criminal capacity or not. So the age limits when it comes to kids, there is certain age limits, and it was recently amended so that they say certain ages a child has the ability to comprehend these actions, and obviously also testifying. Now, obviously, when they look at testifying, witnesses testifying, it's normally from the age of 16, more or less, where they can actually bring the witness in to come and testify in open court. Then, with testifying in open court, they can now hide the face. They can either put them in a separate room using an intermediary. But the thing of a witness to have a choice to testify or not, a witness can say, I don't want to testify. But then the state can use a tool in their armory to say, I'm going to declare you a hostile witness. So then you are going to be brought against your will to come and testify because you have knowledge of a crime that was committed on South African soil. So that one needs to be understood, and that's the position. If you don't want to testify and you say, I don't want to testify, they will bring you. As a hostile witness, they'll subpoena you. So, and the worst that can happen is most probably you can come into the dock there and in the witness dock and say, I don't know what happened. But it might be that you're now opening yourself up for perjury. So that is another thing that people don't understand. You can say, because there might be somebody else that said, but you were on the scene, you saw exactly what happened, and now you say you don't. So actually under oath, you lied to court. Perjury on the table. Okay, so that is where one needs to look at. Then obviously it was you. Then the soap opera, obviously, when it comes to the television, obviously, the behavior of Advocate Tefu or former Advocate Tefu, his behavior in front of the TV, as the judges and magistrates normally chastise people in court very quickly. But I think because the TVs was there, Judge Maumela was a little bit lenient on chastising him because he might be seen as now prejudicing accused 1 to 4, because it seems like Advocate Tefu is fighting for their rights. And now if the judge stops him in his tracks, it might be seen as he's now trying to protect, and then the story of the theories comes in. That theories of there's somebody pulling strings behind the scenes and those type of things, then it will reinforce that idea. So he had to now also manage the situation with the media, and I'm not saying it's bad that the media is there. Sometimes it gets people on their best behavior also when the media is there. You won't do shenanigans in court. And then the issue of the 2 dockets for me, the 2 dockets, that doesn't help this case a lot. For me, it's like you have 1 docket. And if you have 12 suspects, you list them all under the 1 docket. Because the problem is, if you have these 2 dockets, and let's say for argument's sake, the first docket gets run down. They go to trial and they find these 5 not guilty. When they try the 7, what's going to happen? They're just going to say, but it's those guys. And the principle that you guys are going to learn in criminal law, atrifwa acquit, atrifwa convict. You know that principle, ne? Or you heard about that principle. Then they're going to rely on that principle, and then they're going to walk free. And what is going to happen to the Buccaneer question there? Nobody will be brought to book for the murder of Senzo Meyiwa. And then, what is the people out there going to say? Travesty of justice. Our criminal system is not working, and they will lose confidence in the system. Totally. And yes, there was delays, and the delays happens, and yes, we see Senzo Meyiwa's case now in the media. But I can tell you there's other criminal trials called dockets for 10 years. 10 years. So this is not something special. Why is it happening? There's various factors. Our courts, limited staff. The witnesses, not always available. Attorney's diaries, full. Because if I want Mr. Hart to represent me, I'll wait for him until he's free. Because I believe he's the best man for my job. And that all play into the delays that happens in court. And that is why sometimes we think justice delayed is justice denied. Yes, the wheels of justice turn slow. Yes, in some instances it turns quick. And with the pulling of strings, for me, I still feel like the crime scene was contaminated. There was some sort of a staging of the crime scene because the first witness that came on, that Musia guy, what happened in that 7 o'clock to 12 o'clock with that crime scene, it's unheard of. I've spoken to so many forensic experts. You don't leave your crime scene. You don't leave your crime scene unless you hand it over to a competent colleague that's working with you, and then from there onward, that colleague is in charge of that crime scene. You don't leave your crime scene, go to another crime scene, and come back to a crime scene. You don't do that. So there's a lot of things happening, and obviously shifting people into rooms, there's a lot of things that can be tackled. And actually now it comes down to, for me, if I'm the lawyer for accused 1 to 5, I will never put them in the box. I will never get them to contradict maybe what. I will break down the state's case on technicalities. I will ask for a 174 because there's enough grounds for that already. That's my view. People out there might differ from me, but that's my view. I would have said, when the state closes their case, I'm going to go for 174. And just showed, and that's why I'm saying working with the credibility and poking holes in the state's case. So that is my take that I have on the case currently as it stands. We'll still see how it unfolds. 174, Section 174 of the Criminal Procedure Act. It's when you ask for a discharge. I saw from the audience, he's making sign gestures there, 174. But she's a journalist and she knows what's a 174, but I'll explain. It's in the Criminal Procedure Act. When the state closes their case, you then ask in terms of Section 174 of the Criminal Procedure Act for discharge, to say that you are being discharged. It's like a not guilty, without actually giving it. And one of the things is, maybe if the judge say, I'm not going to give you a 174 because maybe I want to check if these witnesses cannot maybe implicate themselves. What I've done in the past, if the judge doesn't want to give me a 174, immediately after he doesn't want to give me a 174, I close my case. So he has to then make a judgment based on that. There is a danger in that he might find you guilty, but there's also a good chance that you can be found not guilty. So that is just tricks of the trade that you learn when you get older in the game. But you need to understand. Okay. I hope I've covered everybody's question. I think Monique, did I miss your question? I got it. Okay.
All right. So first 5, are you guys satisfied? Happiness? Okay. My question in terms of, you asked do I feel the media is playing it up, or we sensationalizing it, or are we, I guess, giving you guys coverage as it happens. And in particular, most of you, like Mr. Peterson was saying, the public was very upset in terms of what happened with the state's third witness, which was Dumelo Madlala. One of the 7 people in the House, he was due to testify, and this was going to be, it's almost a groundbreaking moment in the case, because so far from April, mind you, we've only had 3 witnesses, including Dumelo Madlala, since we began this trial. And at that point, the question has always been, when is the state going to call those who were in the house? Yeah, we're hearing from forensics, we're hearing from the police, but I think, and I've posed it to legal experts a lot, wouldn't you start with the people in the house to lay a basis in terms of what happened, what they saw, and then bring in your forensic experts and so forth? So I think as the media, because the pressure, and I'll speak for broadcasters, is that people want the drama, but with a trial, it happens so slowly. And here was a moment where it was going to be like, okay, now we're getting into like the nitty gritty of actually getting a picture from somebody who was there. The state being, in my observation, the state has been quite hesitant to call people in the house. And I think at this point, it's just a matter of we need to now start actually showing people what happened and what is the basis for prosecuting these 5 men. So on that day, as broadcasters, mind you, and when I say broadcasters in particular, I'm speaking about the TV channels. And in South Africa, when it comes to news channels, there are 3 main ones. You have the SABC, you have Newsroom Africa, and you have ENCA. And I'll speak honestly, while news is the business of informing people, it's a business. It's a business. So my job as a reporter for ENCA is to try and get the information first, is to try and show the visuals first, is to, what I've been doing, I don't know if you've been watching the trial or you follow my coverage, I've been trying to track down people in the house. I've been trying to track down anyone who will speak to me. I've spoken to Kelly Kumalo, I've spoken to Zandi Kumalo, I've spoken to the former police commissioner who was the, at the time, of course, his officers mandated with investigating. I've spoken to Difo, right after his arrest. So I've done a few what we term exclusive interviews in order to kind of give my viewers or people following my coverage more out of the trial. So I've been trying to take court proceedings out of court, which is very difficult to do because you hear the term sub judice a lot, right? And my surprise in those who have agreed to speak to me is the fact that at least 2 of them are implicated or alleged to have some kind of involvement. There is a question around whether they're actually victims or whether they should actually be in the dock forming part of the 5 accused. And when Dumelo Madlala was then called to come and testify, I'll tell you, for me, it was a moment of insanity what happened there, because I've personally, I had no idea what was happening. I actually fell behind at some point with the chase. I fell behind. You can't actually see me in the visuals because I was like, wait, are we really doing this? Like, are we really about to chase after this guy? Because the decision I was making is that, okay, if I choose to not participate in this chase, I run the risk of viewers switching channels to go and see the chase somewhere else. So I'm sorry, that's just what it comes down to, that. And ethically, not great. I own it. I own it. It was not a good idea. But in that moment, it's a split-second decision that you have to make, that, you know what, I'll deal with the consequences afterwards. And the consequence, unfortunately, was a blackout for at least 2 hours. Of Dumelo Madlala's testimony. Thankfully, it wasn't anything major that we had missed, because that 2 hours was the state laying a basis, or his evidence in chief, in terms of what he was going to say. So he was talking about his history with Senzo Meyiwa, how they became friends, their background, etc. And by the time we had apologized and asked for mercy, etc., we were then able to get the cameras on, and that is actually when the crux of the issues started out in terms of what happened, what brought Tumelo Madlala to Johannesburg, and what happened in Fort Lewis. So a moment of insanity, but like I say, in the broadcast industry, in particular for these 3 TV news channels, it's a numbers game, and it's about trying to get that information first. But I do apologize profusely for that media blackout, because it ended up infringing on the public's right to actually have those proceedings broadcasted, which is the main point of us being there, is to allow everyone to be able to, especially for the Meyiwa family that's in KZN, that can't actually come down on every single occasion for the trial, for people who loved Senzo Meyiwa, for Pirates fans, for people who really want to see developments in this trial. That moment, I understand, it angered, so I apologize literally to every single tweet. Everybody who came for me, I said, I'm sorry, I own it, I take my L, because it was completely wrong, and it could have jeopardized the case itself. In fact, the lawyers were very upset with us. But I think the judge was very forgiving. And also, I must say, by the end of the week, applauded us for correcting our behavior. So I understand we have some online questions. Let's move on to those. And then we'll come back to you guys on the floor.
All right, so we actually have 2 questions online, and we have a total viewership so far of 128 currently. So we have 128 viewers online. Obviously, it fluctuates, people come in and out, but yeah, this is where we are right now. So I have a question from Itumeleng Motlatla, and she asks, in my opinion, the judge was also personal towards Advocate Defo in the case. How is it possible that he is not challenged on that? And then there's another question from Michael Mokwena, and this one is directed to Mr. Hart, and it says, very interesting, I would like Mr. Hart to unpack more on his stance regarding the 5 accused. Yeah, those are the 2 we have. We can handle those, and then maybe we'll have a look at a second round online. So if you're still online and you have more questions, you are more than welcome to send them in.
Mr. Kun, I think maybe let's start with you, and then we'll move on to Alton.
Okay, so, I mean, naturally, if any of the parties feel prejudiced, they can apply for the recusal of the judge, but you don't just apply for the recusal of a judge lightly. There needs to be some substantive basis. So I don't think they will just move to recuse the judge because some people might feel like the judge was treating Advocate Tefu lightly. There would probably not be sufficient grounds for recusal. Mr. Hart, you get the 5 accused.
No, on unpacking on the 5 accused, for me, it's like there's still a lot of water that needs to flow into this ocean. But if I look at a case, I don't necessarily look at a version or a view of an accused person. For me, as I look at what can the state present to us to say, beyond reasonable doubt, this guy's committed the offense. And that's where I start. That's my starting block. Because I always work with the stance of, I'm building enough grounds in the event that they find me guilty, I can appeal. That's always my starting block. So I'm not thinking of just the short game here. I'm thinking I need to bring in enough evidence that if I go on appeal, I can be successful. Because remember, on appeal, you need to deal with the appeal record only. You don't introduce new evidence. So with the 5 accused, I would normally try and say, I want to get them to 174. And this is now section 174 of the Criminal Procedure Act. Let me just be clear on that. So that I get there and I ask the court to preliminary rule. So once the court makes that preliminary ruling, I can then see from the decisions of the court, what is the court already looking at if I'm going to go into now calling defense witnesses. So the defense witnesses, and I would normally call my defense witnesses right at the end. I would first call my witnesses that can maybe corroborate a version of mine, but my own accused person that I'm representing, I call them last. Why? Because then they've already heard what the experts are saying, what is the witness saying. They've been sitting there. It's now the unfair advantage that they will have. And then they can line up. They can line up, which is not a good thing to teach you guys, but that's how I think. Some people will think that, okay, I'm going to now go and call my accused person first. Sometimes you only need to call your accused person to say, I was not there, because the state hasn't proven maybe by GPS signals, because there's so many things they could have done. They could have taken these guys' cell phones and tracked what number were they using back then to see at the time of the incident, was these cell phones even picked up by towers here? That investigating officer didn't do that. So there's so many questions pertaining to the accused persons. And the one that's now been pointed out, accused number 2, and people will think, yeah, but he was identified in the doc. Doc identification for me doesn't carry weight. Because if there's 5 people in the accused box and I say to you, sir, do you see the people that committed the crime in the court? I'm already narrowing it down to the court. Né? And if I go even further, I say someone sitting in a dock, then you know it's 1, 2, 3, 4, 5. I must choose one of these 5. So doc identification for me is the last thing I'm looking at. Now, you have a 32-year-old, unblemished record. He has never crossed paths with the law, not even maybe like for avoiding his maintenance order. He suddenly at 32 years of age decide, I want to be a criminal. You ask yourself as a lawyer, you need to interrogate this. Is this maybe even the right guy? Because sometimes guys with criminal, and specifically guys that goes out doing these aggravating crimes like robbery and those type of things, that's a trait you learn very young. You start maybe robbing people with a hockey stick, then you upgrade to a baseball bat, knife, and then you go into this other one's gun, or the smash and grab that the students know here around campus. You drive with the Uber, stop, grab the cell phone, jump in. Then you upgrade. That's criminal behavior. You don't just start somewhere at 32, I'm going all out. COVID has made me mad. So that's how I look at these things and unpack and I say, is it reasonable what the state is proposing to me here? And once I start seeing questions popping up, then I'm starting to say, okay, maybe I need to look in here. I need to dig here. I need to delve here. And that's how I go with each one. Obviously, the ones that is already incarcerated, I would go and look at what were they incarcerated for. Maybe this guy, he's now being charged with robbery, but maybe his line of crime is something else. Maybe he's a hacker. He's interested in hacking people's computers and stealing their money there. Robbery because he's not confrontational. You start looking at your accused person's personality also as to what he gets himself busy with. And that's where I look at the accused and then I prepare my case and what I'm going to present if I need to present a case for my accused version to say, this is what my accused is about. Not what the state is portraying him. Because the state is trying to portray that this is a criminal and he's bound to commit crimes and he's been doing crimes. And that's how you look at these types of things when you look at people in the dock as accused people. So that's how you prepare also your case. You start, I prepare, I take my instructions for the bail, but in taking bail instructions, you take for preparation of trial, you take for sentencing, and for the appeal when you do your things. That's how I normally would go about it, and I would do it so in the case as well. Thank you.
Thank you. So we'll come back online in case there are more a bit later, but I will now move back to the floor. Woo, it's gonna be a good discussion today. Okay, so I'm gonna move up here so that you guys can see when I'm pointing at you. Okay, so the ones who have already had questions answered for, how about you guys wait for round 3, nah? If we have time. But let's start with 1, 2, 3, 4, 5. 5, and then depending on their questions, 6, 7. Ne? Please note your numbers. Ne? So it's 1, it's 2, it's 3, it's 4, 5, 6, 7. Perfect. Cool. All right, don't forget to introduce yourself, what year you're in, and then your question. Back to you, number 1.
All right, good evening, everyone. My name is Kudzai Taravinga. I'm a second-year LLB student. And my question is directed at anyone at the panel. It's quite broad, and it's a question that I've been confronted with as a law student with the public or people that presume that I know every nitty-gritty of what's happening in the case. So what the biggest question that they've been asking is that, do you think that the tampering of the crime scene and the fact that the police commissioner who was supposed to be at the crime scene, his disappearance, do you think that has influenced the delay in getting proper evidence in the case, and therefore, because there's a lack of evidence because of the tampering that allegedly happened, do you think that has played a big influence in the progression of the case? And do you think that there's been foul play from the higher powers? It's one, basically dealing with the tampering of evidence, and is there foul play? And that's it, thank you.
Good evening. My name is Ntabile Ndikwebe, and I'm a first-year law student. So my question is directed to Mr. Hart. So we know, like, under criminal procedure, we have a part whereby the IO will submit a docket to the prosecutor, and then the prosecutor will decide whether to prosecute the case based on having, like, whether there is a prima facie case, right? So in this instance, you spoke about 2 dockets. So how did they prosecute the case in the first place if there are 2 dockets? Because it doesn't make sense. And also regarding former advocate, therefore, so his arrest, we saw, like, when the court was adjourned, he was arrested. So what do you have to say about that? Like, was it the right procedure to arrest him like that? Thank you.
Sanbonani. So my name is Sarula Siyema. I'm a first-year law student, and Mr. Kun is my teacher. So, so my question is in relation with the multi-choice, I think it's paragraph 27, where the gist of what is being said in that paragraph, it is that the rich and famous are actually treated more favored and are treated differently from the masses who do not have their same status. So my question is, do you think that perception, it emanates from the idea that our country back in the days was oppression? Do you think that that perception emanates from that? And if that's the case, how do we begin to actually change the narrative and also promote the spirit of inconclusivity where people can see the court and say that the court are not just for the selected few, but the court are for all the Republicans of South Africa? That's my question.
Hi, everyone. I'm Komoto Mufamadi. I'm a lecturer here at the University of Johannesburg. Thanks, colleagues. This has been so interesting. And I've got 2 questions. The first one is a little bit, it's kind of 2 also. So the first one relates, Alton, I'm sure you've seen the documentary that was on Netflix. So I want to know, number one, what is your view in relation to a lot of the narratives that came out of the documentary? And you can touch on any that you can sort of remember, because we are, as the public, are running with those narratives, I think, whether or not they are reality or not. And also, is there any implication of all of that stuff coming out in the documentary before we actually see it come out in court? Is there any implication in law? There must be something in the CPA in relation to evidence being out in the public. My husband is whispering tips to me. And secondly, Mr. Kun, we've talked about this a lot, but I want to get your sense, and from both of you really, we see so many cases that are hot cases, the big, sexy matters, so to speak. And you touched on a little bit, Alton, when you spoke about how there's so much that happens behind the scenes or before you even get to trial. And is there not some interest, is there not some greater good in the public getting to understand the real implications of a court process? I often worry that the media is so obsessed with those big cases. I mean, how many of us are going to be charged with murder, ever? or know someone who's been charged with murder or be involved in a murder trial. There are so many areas of law and issues in law that ordinary people deal with every single day, and isn't there a lot of significance in those types of matters, the small claims court matters, your CCMA types of matters, or smaller petty crimes coming to trial? I know it's not as cool, but is there not a need for those types of matters to be broadcast as well? Number
5. Greeting to the panel and the audience. My name is Vumile Ngulega, a first year LLB student. So my number one question is that it's based, or everyone in the panel may answer, that because we can see that the trial is so slow. So what may be the impact of the trial being so slow, and what can the courts or the legal system do to make sure that the trial it's become so quicker? Because it may happen that the person who is behind the killing of Senzo is still out there, not arrested, not in the custody, and it may happen that that person may die before even the justice is served. So my question is that what can the legal system do to make sure that that person doesn't die before the justice is served? No, it's really, and
Greetings to the floor and large. I am Nomo Tabuchi. My question is likewise central to an inquiry advance of the two dockets for the same course of action of the case in question, right? And which is a conduct that is itself legally unacceptable and which could potentially give birth to a legitimacy crisis. Therefore, Mr. Hart, does this relate to incompetency or duplicity? Thank you.
Good evening. My name is Mapula Matli, first year LLB student. So my question is directed to Ms. Masekane. So those that were present in the house at the time of the incident, their role in this case has been super controversial to the public eye. And like you've mentioned before, that they might add to the list of victims or might as well add to the list of suspects. So with, according to your knowledge, insofar as the case is concerned, I would like to know your perspective on what you think specifically to this one. Thank you.
I'm just going to hand over to Mr. Hart and Mr. Kuhn to just start with those legal questions, and then, of course, I will end off with my one. Mr. Kuhn?
I think let's start with Mr. Hart, because the first question is to him.
Okay, I think the first and second questions was running together, and they specifically dealing with the crime scene and how the crime scene was handled. And that, for me, as I said earlier, leaving your crime scene is a no-no. Because the moment that crime scene, which is critical to the evidence for a court to say, listen, yeah, this person has committed the crime or not, is critical. If you leave that part, you're giving Mr. Hart something to shoot at you. That's my stance. So if a crime scene is left unattended, if a crime scene is contaminated, you'll have a trial within a trial. Now, a trial within a trial, you guys will get to know it's what they call interlocutory proceedings, where you say, this evidence that the state wants to present to court, is it still admissible because of the tainting that has happened? Because now everybody could come in, and obviously there is already this theories, and it speaks to my colleagues' question also about the theories that was there a cleaning of the crime scene, and one of the people even said that they came in because they didn't want people to see as much as moving a beer bottle on that scene is tampering with the crime scene. And that is unacceptable. The crime scene must, if something happens here now, all of us, we must just get up and get out. Leave it as is, they must find it as is. The moment you start moving and tampering, then it's no longer as it was when the crime was committed. You might think something is unimportant to you, like maybe to move the crutch from this side of the room to that side of the room. But for the forensic evidence, and obviously the amount of photos that was taken on that scene, I think the first time he took something like 7 photos. Or 8 photos, something there. Now, I spoke to my colleagues in the forensic. Normally on a crime scene like that, at least you must come out with something like 30 to 35 photos, just on the first glance. So for me, there's already problems galore. And for me, that already travesty of justice, it's gonna happen. And obviously, if the guy is found guilty, then you start wondering, hey, was this guy not done in by the system? You start asking, but obviously for the people who want somebody to be convicted, they say, hey, no justice for Senzo Meyiwa if these guys is not found guilty. So that type of things is there. And obviously if you look at the Criminal Procedure Act, how you deal with these things, and obviously my colleague asked the question, Komoto asked the question pertaining to the Netflix series, and I think most of you guys watch the Netflix series. Now, the third witness for the state said, I don't want my face to be shown. But he was gladly and easily sitting on Netflix there, people see his face. So the competing interest to say, like, my privacy is now being infringed upon. People has already, if I want to see you to Madlala, I go put on Netflix and I see, okay, it's him. So once you've seen his face, it's out there in the public. He has then waived his right. He has waived, if he can say that, he has waived his right. And I think there the judge was a little bit hard on the media to say, don't show his face. And this is the guidelines that we want you to play by. But I mean, if the judge would just think, but man, you've waived your right. What privacy is there? What your face is out there, it's public. And court proceedings is anyway public. So that for me is already a thing that I don't think he can hide behind. So people want to know, and obviously, in defense of my colleagues, and I know media, it's a business. We want to say maybe the media should have done that, but it's all about the numbers. And me even sitting outside, I can say, I can see, it's numbers. And it's like when I come with 2 breads in the house. One was baked yesterday and one is baked just now. Which one are you going to eat? The one that was baked just now, nah? So, same with the media. The news that's off the press now is important to them, not yesterday's news. So give them a break sometimes. So I'm not saying everything they do is right, but obviously you need to understand the numbers. And the taking slow, there's nothing we can do as practitioners about it. Obviously, the court systems, there are certain things that's built in that you cannot avoid and deny. So it's built in there. You have to deal with it. And obviously, when you look at it, why is it taking so slow? And obviously, it speaks to the 2 dockets. And the other question was that, why is it now you decide to prosecute and now you decide to prosecute? Obviously, this whole case is tainted for me already. And when the one DPP, because the one is like a 2014 docket that was opened, and the other docket was only opened later, 2019. And the thing is, how these people did, it was the one DPP for South Gauteng and the one DPP for North Gauteng. Now, if you guys would know, we've got a provincial division and a local division in Gauteng, and they are split. So sometimes what happens in the one office, the other office doesn't know. And that's how these 2 dockets were seen, and they say, let's prosecute on this one. Maybe if the South Gauteng DPP back then also knew that the second docket existed, he would have said in 2020, no, maybe we shouldn't. Maybe we should actually consolidate this docket and make it 1. And maybe we would have gotten 12 accused and not 5. And I still believe that 12 should be there. 12 should be there, which I think the 5 will be eliminated. But that's a story for another day. So taking it slow, and I think Mr. Koen will touch on the media ones. I think the media ones was the guys there. But my colleagues, you must indicate if I did not touch on your question, if I've maybe omitted something, but I think I've covered you guys. To an extent. And Advocate Tefu's part that he was arrested in court. There's nothing wrong with arresting a person in court. And I know now there was like this outcry, why do you arrest the guy in court? Yes, maybe one can now speak to, maybe they wanted to drive a narrative home to say, listen, yeah, if you don't keep quiet, we'll shut you down in a different way. And that's the perception that people got out there. But obviously, if an investigating officer is sent by his commanding officer, say, listen, here's a warrant, go and arrest the person wherever you find him. And wherever he's in a courtroom also. The court wasn't in session. So the court was adjourned. So he was just in a court building, which is a public building, which is open to the public. So he can be arrested. So that is the one thing. I think I saw my colleagues was lifting their hands. Was there something that I missed? Okay. Thank you. Mr. Koen.
Okay, so I think with all of the first year students who are here, people might think I threatened the students to attend. I should clarify I didn't. Okay, so the question is, does part of this perception arise from the idea of our past? And I think in South Africa you can rarely speak about where we are without speaking about the past. For a very long time, the law was a powerful tool of oppression. And to think that people will forget that overnight would be foolish. So yes, I definitely think some of the perception of the courts as essentially an institution that protects the rich and powerful partially arises from that past. We cannot ignore that past when we consider where we are today. I think also the challenge is, if we're being quite honest with ourselves, the reality is, if you have money, you can afford good lawyers. And unfortunately, legal fees are very expensive. The reality is that everybody is not going to have the same quality of legal services. And I mean, Mr. Hart and them are doing brilliant work in the law clinic to help people who cannot afford it. And like the legal aid, we cannot fault legal aid. But if you go to legal aid, they're overwhelmed with many cases where you're paying a private attorney. Yes, they've also got many cases, but they can give more attention to you. So that also contributes to that. And then to Khomotso's question, and I should disclose, Khomotso and I have published on the broadcasting of court proceedings together, and this is a view we share, that unfortunately the reality is that what we are seeing on television is the hot cases. It's the high drama, and I think it gets back to the numbers issue, because if you really want to drive the viewership, that's what you're going to want to broadcast. And that is what made the marijuana cases quite interesting, because there we saw a move away from it just being the media that's broadcasting. So in Fields of Green, it was a private organization that actually applied to live stream it to YouTube. But now we go back to the comment by Justice Mlambo in the multi-choice case, where he said that the entire idea of opening cases to broadcasting is to make it accessible to ordinary people. With high data costs in South Africa, the reality is that if you're trying to reach the entire population, a YouTube video is probably not the ideal way to do that. But many other people would see those cases who wouldn't have been able to see it. So it's an improvement, but unfortunately I don't think we've got ideal answers on that. So I agree that we need to broaden the scope of what we broadcast, and perhaps you can speak to some of that as well. But I think it does come back to the business aspect as well. Even if we want to see open justice as being real open justice where all is open, unfortunately, I don't think that's going to happen anytime soon.
Yeah, maybe I can just stay on that point in terms of, like, resources within newsrooms are depleting literally by the day. Budgets are being cut. You know, people are being retrenched, the economy is not doing great, meaning businesses in the media are not doing great, which is actually an injustice, you know, in terms of us being able to disseminate information and give information to the public, is that newsrooms are getting smaller and smaller. You're getting fewer and fewer and less reporters who are then tasked with doing more and more reporting of everything. You know, I call it being, what's the term? No, something, jack of all trades, but a master of none. So one day I'll be doing politics, the next day I'm on an environmental story, the next day I'm doing business, the next day I'm doing education, so I have no time to dedicate to a specific beat. We call it beats in the media, where I'm solely focused on educational matters, for example. The SABC, which is a much bigger platform that has a far wider reach and has many more offices and resources and is funded by government, can actually have so many reporters that they can dedicate to specific beats. So you will find that their radio platforms, their TV platforms will have journalists dedicated solely to court reporting. Lately, that's what I've been doing a lot of. And in particular with this trial, I find myself in court all of the time. So one would say I specialize in court reporting, but at the same time, the issue with the fact that you find more sexy cases, we say when it bleed, it leads. It doesn't sound nice, but that's the truth, is that bad news usually is what will be a top story. And a case like this one, which has so many moving parts to it, which has so many complexities to it, just the mere amount of time it's taken to get here, who the person was, what happened surrounding his death, the issue of 2 dockets, the issue of the time frames in which we still don't know exactly when he died, what time he died. All we know is that police were called in at around 9 p.m. To respond to what was a shooting in progress. And to answer your question, I can't actually tell you what I think about this case. I do have views, but I can't tell you that because it would be bias. You know, you guys would then, when you're reading my reports, you would have an idea that I think perhaps these guys are guilty. I don't know if these guys are guilty. Maybe they're guilty. I don't know. You know, I'm in court to show you whether the state has enough evidence to prove that these guys are the ones. And I'm giving the defense an opportunity as well to show you guys whether there's enough evidence against the 5 men accused, or whether there could be another scenario. Because if you think about it, essentially we have 3 scenarios. So either 1, there were intruders, either 2, somebody shot in the house, shot Senzo Meyiwa, or 3, it was a hit. Those are the 3 scenarios that we have basically playing out. And at this point, it's so early. You don't even know. I mean, we're literally only on the 3rd witness. And this is the first one in the house who's telling us what they saw. And even then, a lot of what he's saying is, I can't really remember the date, I can't really remember the time. So those are the things you pick up and you note. And unfortunately, you guys can't see him in court, but I can tell you that the demeanor of somebody when they're testifying tells you a bit. You know, you kind of pick up little nuances. You can see when the defense... you can see when they've picked up something that's a discrepancy, or something that doesn't corroborate with what they initially said in an affidavit and so forth. So for me, unfortunately, I cannot tell you what I think. I do have views, but for me at this point, my job is to just report. So I want to keep it at that. Questions online? So let's take some questions online, and then we will come back to the floor if there are any. Also, I just wanted to add on the issue around former Advocate Tifo. I know people seem to have the perception that he was just barred because of his behavior in the Meyiwa trial. It has nothing to do with his behavior in the Meyiwa trial, believe it or not. He had more than 20 complaints against him lodged with the LPC relating to fraud, relating to forgery, relating to just poor conduct of himself as a lawyer. So those who think he was targeted, I don't think his behavior in court made it any better for him, because here he was publicly, you know, kind of, I don't know, going head to head with the judge, being disrespectful to his colleagues, you know, saying that they weren't learned colleagues. You know, there was just so much happening. I think he brought so much attention to himself. It was difficult for the LPC now to ignore the complaints that were already lodged against him. So I don't think he did himself any favors, but I want to clarify that his disbarment has nothing to do with his conduct in the Meyiwa trial. It did come up that there was an issue that was raised with regards to his conduct in the trial, but the main issues were around the fact that he was apparently signing, representing people without the instruction of attorneys. He was forging signatures. It was a lot. It's actually shocking. Perhaps you should do yourself a favor and read up on that actual case, because a lot of the conduct, my question was why it took the LPC so long to get that case or his matter before the court, because over 20 complaints is just of, yeah, which predate. I think somewhere about, they date back to around 2019. So in my view, I feel like there was a bit of a slow pace in resolving his issue, and then he went and decided, I'm going to be in this high profile case, and now he is the people's advocate and people love his, robust, or should I say, it wasn't, his behavior was just not normal in terms of decorum of lawyers, you guys call it, and how you must address each other. So just some clarity on that. Let's go online.
All right, so we are sitting right now on 132 live viewers, so it keeps on growing. And so I have two questions from Cyprian Lukele, but before I go to those questions, I just want to read a comment from Ngabuto Dube, who says, the problem I see is trying to bring the two dockets is that the 7 accused are charged with a different case. And that is the case of defeating the ends of justice as in cleaning the scene and having knowledge. And that is Ngabuto Dube's opinion on the 7 accused, or the 2 dockets as well. So Cyprian Lukele's first question reads, how much weight does the confession made by the accused have in this case? Will it have effect which may incriminate the accused? Effects. And the second question by Cyprian Lukele again reads, so during the confession, is the mental status of the accused considered? Because a possibility that some negative factors like threats would prejudice the accused in the proceedings.
Perhaps let's deal with those 2 questions so that I can come back to the floor.
Do you want to start, Mr. Hart? Or?
You can start if you want.
Okay, I think what's important for us to remember is that a court will not just convict somebody based on a confession. I think that is just something we need to clarify, that a confession by the accused is never enough to convict solely on that basis.
Yeah, obviously, if you come to confessions, one needs to check. And today in the bail application, specifically for accused number 2, there was an issue of 2 confessions that came up. The 2 confessions, and he alleged that he was tortured and actually forced to actually, or coerced to actually make these confessions. Now, one needs to check. There's specific provisions in the Criminal Procedure Act as to under which circumstances a confession can be made and should be made, and then the court can actually attach certain weight to it. But a confession is still far away from an admission. So you guys must just remember there's confessions and there's admissions. And then also that things that you find in the 115 plea also speaks to this. These things, they look the same, but they are not the same. So admission is like where we say it's out 220, it's recorded, it's not in dispute, this is what happened. A confession, one needs to now check. How was it made? Was it made before a peace officer or a commission of oaths? Those type of things. And then one needs to now check if the person challenging this confessions that was made, then we go into what we call a trial within a trial to see if this confessions is admissible or not. So today, what played out in the case specifically is that the state relied on these confessions in the bail application to try and say, but this person made confessions, so the state has a strong case against him. That for me is not enough. I think the state was clutching at straws there, because he's already saying that they've tortured me and they took away my blood clothes. Obviously, ever since they arrested him, he was in custody. So they can't say, where's the blood clothes? And they don't have blood clothes, because they could have easily just moved it away and say, now the confession stands, because whatever you're alleging, there's no evidence to that effect. So one needs to always look at these things very cautiously. And the confessions for me, if I would be a presiding officer, I would not even look at those things. Because sometimes, and over my 17 years that I've been doing this, I've looked at some of the confessions, then you see, hey man, this confessions of a specific investigating officer, why is it always looking the same? you can go and you'll pick up trends when it comes to confession, statements that accuse people, and then you as a lawyer should interrogate and say, listen, yeah, I need to challenge this. But obviously, the state cannot solely rely on those type of things. But for me, confessions is a very dangerous thing, and a judicial officer should be wary and very cautious when dealing with these confessions. If it's an admission in terms of 220, that's a different ballgame altogether. Then you can put a little bit more weight. You can actually say it's now no longer in dispute. We're just dealing with the issues in dispute. And you guys will pick it up as you grow older in your law careers that there's confessions and admissions, and under different circumstances it can be admitted. A confession, you still need to jump a couple of hoops for it to now be accepted by the court. You still need to come to court and prove, although it sits there in a confession, to prove every element of that crime. While an admission, if you admit an element, it's now out of dispute. Okay, I hope I've touched that for online there.
Fantastic. Do we still have questions on the floor? Yeah, I think we still do. Okay. Is it just 2 hands? 3? Anybody else? Okay, I have my own questions, so. Okay, so number 1 right at the back, number 2 somewhere here in the middle. Where's number 2? Where's number 2? I can't see number 2. You? Is it you? 2 and then 3. Okay, cool. Is there a mic for you guys there? Just pass it back, please, guys.
Thank you. My name is Tepiso. I just have a question for Mr. Hart. Colleague, I heard you talking about, so one of your answers, you spoke about, what is that? Oh yes, tampering with evidence. Yes. So what I want to ask you is that, so the police officers who went to the scene, these people are expert in dealing with evidence, right? And you also made a comment that you can't leave your scene and then come back. So in this case, I had one comment that was read to us about the other docket being people who were charged with tampering with the evidence. So I'm not sure about that. So I just wanted to talk about it in terms of the officers who went to the scene. So police officers who went to the scene are seen as experts in dealing with evidence. And if one doesn't deal with the evidence properly, isn't there supposed to be a charge against them for defeating the ends of justice, just for tampering with the evidence? Yeah, and so I actually work with SAPS, and I know that sometimes things is rough. So but actually what we do, we work. We monitor their conduct. For the department that I work for monitors their conduct. I'm also, I've never had a complaint about that also, to say these officers did not deal with the evidence properly, because usually someone will report this and say these officers were supposed to do the proper thing because they know how to deal with this. Why was the bottle moved? Why was the ballistics not handled properly, and all those things? But I never saw anything about that or heard anything about that since I was there at the department. So yeah, maybe you can explain to me, why are they not charged for that?
Okay, my inquiry is directed to any one of the panel, and there was an instance where Advocate therefore wanted one of his clients to be trialed separately. So my question is it legally acceptable for a trial of such a nature to be conducted?
Thank you. My last question, we could say it's two, directed mostly to Mr. Hart and Mr. Cohn, of course. Apparently there was a student that witnessed the people getting in, and he said there were 2 cars, there was 5 people, 2 inside, 2 outside, and 1 in the car, and the student was actually killed, and the general belief is that he was poisoned. So how, in such a case, how was it possible that no one was put in witness protection? Because this is actually a dangerous case, because there was someone that lost their life. And the second question is mostly directed to Mr. Hart, because you said something about letting people speak and then letting the accused speak last because they've already heard. So letting the forensic reporters and everything speak first and letting the witnesses that were in the house listen to what the forensic people are saying first, does that not give them a chance to maybe alter their statements into saying what the forensic people said, which also gives rise to the belief that there were other people that are actually pulling the strings behind? Thank you.
Grace, I'm going to move back to the podium and then allow our panel to just answer those last round of questions, unfortunately.
Okay, tampering with evidence, and obviously if a police officer is involved in tampering with evidence, obviously that is a charge that you lay with IPID, because IPID is the director that deals with complaints against police officers being incompetent, not doing their jobs, so that is where you actually go. So as the family, the Meyiwa family, if they feel like maybe after the trial, it's now clear from what has transpired in the court proceedings that these officers actually destroyed the crime scene, messed up the evidence, they can go to IPID and lay a complaint so that the conduct of these guys be looked at. So that abetting these fugitives that has committed the offense, that is then a criminal charge. So one needs to just distinguish between who is the perpetrator that does what. So when it's the police officers, you deal with them with IPID, and if you guys don't know what IPID is, it's the Investigative Police Directorate that looks at complaints against police officers. So if you have a complaint against a police officer, that's where you go and complain, and they will then internally first look at their behavior to see if there was something untoward about their behavior. Then when it comes to the crime scene, then that's the job of SAPS that will deal with witnesses or bystanders that actually interferes with a crime scene. Obviously what happened there is like, they allege that 7 o'clock they left the crime scene, they went to hospital with Senzo Meyiwa, who's now late, and between then 7 and 9, that crime scene was not taped off. So that crime scene was left unattended. That already means that anybody could walk in, remove what he or she wanted to remove, and then it means that that crime scene was now tainted. So that for me, that evidence should be treated with utmost caution. So for me, there is already a problem. And then it speaks to this man's narrative here that he says that strings is being pulled behind the scene. And I mean, this is something that I also had to mention earlier. For me, it was the first time that I hear MEC of safety comes to a crime scene. What does the MEC of safety now again know about how you conduct yourself at a crime scene? Yes, they are MEC of safety. They are being briefed. So for me, that was the first to say, that's a red flag already. Not that I'm speaking to the theories, but I'm saying, why is the MEC there? Even a police commissioner doesn't come to a crime scene. I mean, River Steenkamp was shot. You didn't see the police commissioner there. So this one, why specifically? then it starts speaking to people's theories. And I'm not saying now support the theories, but I'm saying the perception out there is then what will make you get out of your bed at 11 o'clock to go to a murder scene? It might be there is a vested interest for you. So, and then it speaks to that theory. And for me, that is now the sad part of it. And we'll see how the trial unfolds. But there's still a lot of things that will happen. And obviously, one of the gentlemen also, I think he was also asking about the sequence of calling witnesses. And you can see the state. They're calling their forensics already. And that's a ploy. There's nothing in the Criminal Procedure Act that says you must call the A1 statement first. And the A1 statement is normally the person, we call it the A1 statement, it's a complainant, the first complainant, or the first witness. So in the case of a murder, the A1, the deceased person can't make a statement. But maybe if it was a robbery, then who was robbed, you will be the A1 statement, and then the A2 will follow as the statements come in. And you'll see in legal terms, we just talk about a A1, a A2, A17, those type of things. There's the witness statements. It's stuff that comes in part A of the docket. Part B will be your exhibits. Part C will be your investigating diary. So you'll hear they talk about A1 statements and that. That's just what it is. It's just fancy jargon trying to be clever. But for me, that's where you go look and you see the sequence, not prescribed. So I can choose who I want to call, and I can even choose that not to call my client. As long as I see that the state has not proven beyond reasonable doubt to prove any wrongdoing by my client, I can close and say, this is the evidence I'm going to tender, but my client is not getting in the box. And normally, as a matter of ethics for lawyers, if you know your client has committed the offense and he has told you, you are obliged to keep that secret because attorney-client privilege. But you cannot mislead the court to say, my client has not done this. Then you have to work with the technicalities in the state's case. Break it down there and ask for a not guilty. Not that you say your client did not commit it, that you say that the state has not proven beyond reasonable doubt and all the evidence that has been tendered cannot be and is not admissible at court. Then obviously there's limited evidence and then the court cannot, beyond reasonable doubt, make that finding against your client. And that's how you work with criminal trials. And not to say, because that perception of lawyers lie. No, if you lie, you get disbarred. Thank you.
Yes, okay. I'm so sad. I feel like that time, like it just flew by. But honestly, I think we've had a very engaging. I hope it's been fruitful for everyone here. I hope you guys have felt like you have gained something out of it. Like we said, this is a trial that's still in its very early stages. If you are following it, I'm assuming you are because you're here. We're back in courts in November for about 3 weeks. After that, we have no idea. There are discussions around end blocking the trial. If you don't know what that is, I can't help you. Your lecturers will unpack that for you. But of course, thank you all for engaging, especially with our online audience, the media team here for making that kind of facility available, the Prof. Thank you so much for hosting this discussion and facilitating and arranging it, to Mr. Alton Hart and Mr. Kuhn for availing themselves to be here and engaging with you guys. A big thank you to them and to you guys for actually being here, especially the first years. Clap, like, give yourself a round of applause. It's really good for you guys to participate, and if your faculty has more of these, I would encourage you to actually participate, because it's you usually get so much more information out of it than you would. I mean, I think there's some gems that have really come out from the panel. So with that said, thank you so much for being here. Farewell, good night, take care, and be safe.